Friends, in my last video, as far as that comment box is concerned, one comment was made in respect of making a video as far as section 106 of the Evidence Act is concerned. With due respect, I'm going to make this video and let me share it. Section 106. First, I would like to read Section 106 of the Evidence Act. Section 106 says that burden of proving fact, especially within knowledge. The term especially plays very important role. I would comment on later. When any fact is especially within the knowledge of any person, the burden of proving that intention is upon him. That is section 106. Now, illustration is given under that section. Illustration: A is charged with traveling on a railway without ticket. The burden of proving that he had a ticket. The burden of proving that he had a ticket is on him. This is an illustration given in that section, section 106. Now, for better understanding of this section, let me have some judgments. I am going to discuss some judgments now. As far as section 106 is concerned, the important judgment of Honorable Supreme Court is Shambhunath Mehra versus State of Ajmer, AIR 1956 SC 404. In para number 8B of the judgment, Honorable Supreme Court held that section 106 is an exception of 101. Is an exception of 101. So now what is section 101? Section 101 says that if A says B has committed a crime, A must prove that B has committed a crime. In para number 9 of the said judgment, Honorable Supreme Court held that in a criminal case, burden of proof is on prosecution. This is the general rule. And section 106 is certainly not intended to relieve it, of that duty. Honorable Supreme Court further observed that the word especially mentioned in section 106 means facts are preeminently and exceptionally within the knowledge of the accused. That's why I said earlier that especially played very important role. Now, in para number 11 of the said judgment, Honorable Supreme Court further observed that section 106 cannot be used to undermine the well-established rule of law that, save in a very exceptional class of case, the burden is on the prosecution and never shifts. And the illustration given in that section, that is section 106, which I have stated earlier, does not exhaust the full content of section. Friends, this is the judgment of Honorable Supreme Court. Now I would like to discuss another judgment of Honorable Supreme Court, State of Rajasthan versus Kashiram, para number 22. It says that if a person is last seen with deceased, he must offer an explanation as to how and when he parted company. He must furnish an explanation which appears to the court to be probable and satisfactory. If he does so, he must be held to have discharged his burden. And in case if he fails to offer an explanation, what would be the position? The position, on the basis of the fact with his special knowledge, he fails to discharge. If he fails to have any explanation, then he fails to discharge his burden cast upon him under section 106 of the Evidence Act. Now friends, in another judgment, Honorable Supreme Court says that the judgment is Ram Gulam Chaudhary versus State of Bihar, 2001 8 SCC 311, para number 24. Honorable Supreme Court held that 106 may not be intended to relieve the prosecution of its burden to prove the guilt of the accused beyond reasonable doubt. But this section would apply to the cases where the prosecution has succeeded in proving facts from which a reasonable inference can be drawn regarding death. So to conclude, it can be said that the presumption of innocence of the accused is not snatched away by section 106 of the Indian Evidence Act, because it is the basis of criminal justice. Friends, you may find my last video somewhere on the screen. If you like my videos, please do subscribe my channel. Please comment on the comment box. Your comments encourage me to make more and more videos and to spread legal knowledge. Thank you very much.